Hi, this is Irina Shea, and this is part of our Wealth and Wisdom series. Today, we are going to talk about the difference between incapacity and death planning in the context of estate planning. So, with that, I'm going to share my screen with some thoughts. Um, if you want to think of this in sort of three stages, we have right now alive and well. Okay. Then we always have the possibility of incapacity, not good. And then ultimately, we are going to be worried about death. Okay. So, how do we handle these stages, right? While you're alive and well, the only thing you need to do is think about financial planning and estate planning, but you're otherwise handling your own affairs, total autonomy, okay? And agency over your own life. That is great, but that is not the forever story, as we all know. We all have family members, personal stories. It's just the reality of life. We are living much, much, much longer, and there is very likely for most of us to be some time period where incapacity could occur. It could be an accident, right? It could also be an illness or something sudden, a stroke, who knows? But then who would be in charge of us in that case? We get to choose, right? We use our own autonomy and agency to choose proactively who would be in charge. So let's talk about that. If you're incapacitated, the key estate planning documents are power of attorney for finances, right? And a healthcare directive for medical. And what is that broken down? It's a healthcare proxy, naming another person to make your decisions. It's a living will to allow for pulling the plug. And it's a HIPAA waiver, allowing your agent to communicate freely with your medical team. Okay. So very important. If you die, as far as I know, everybody's heading for the exit sign at some point, right? If you die, you need, so this is the death portion, right? You need at a minimum a will or a revocable living trust. Okay. Why? That says who gets what, when, and how. Okay. In your estate. So these are distinct phases of life that you want to be able to say in advance how they're going to go, or at least who's going to be in charge of you, whose judgment do you trust, right? So you will definitely want to think about incapacity. If I had to say, of all the estate planning documents that we do, what is the most critical? It's this one. It's this very short document called the power of attorney, because without it, you're looking at a guardianship proceeding, and that is a nightmare. It's extremely expensive, public, invasive of your privacy. But if you don't have this very basic thing in place, it is a serious problem. For people with more assets or more complexity in their family dynamic, another great incapacity document, it's more advanced, but is a revocable living trust, because not only does it cover death, who gets what, it also can be funded during life. So incapacity is smoother. What do I mean by that? I mean, your adult child or your spouse can take over your care, your finances, costs, logistics of this time period where otherwise you're not able to manage yourself as we would prefer always, but that is not always going to be the case. So, in a nutshell, that is the difference between incapacity and death planning. Estate planning is holistic, it looks at all aspects and sets in place a plan before you need it, not in an emergency. You do need mental capacity to do any estate planning documents. You have to be here in category one to handle two and three and set it up. Okay. So don't wait until things are dire. Handle it now. If you'd like to learn more, you can go to our website at irinashea.com, click on the Get Started tab. Our consultations are free. Thanks.